The article titled Advisor Banned for 5 Years for Misleading Super Advice from SMFS Advisor poses as a perfect example of how going against the client's wishes and disregarding regulations will lead to consequences. In this particular article, written by Tony Zhang, the issue of misleading communication towards clients is highlighted by one particular financial advisor named Christopher Chan. Mr. Chan suggested inappropriate advice to his clients, suggesting they should transfer to another super fund. Through investigation by the Australian Securities and Investments Commission, or ASIC, Mr. Chan is found liable delivering undisclosed information to his principal, the clients, and profiting from them, as they unknowingly pay higher fees. In legal situations, the agent is generally not liable unless they have intentional liability, have an undisclosed principal, or breached a warranty of authority. In Mr. Chan's case, he had many undisclosed principles. This issue is important because many advisors can fall for the same trap of picking their own best interests instead of the client's, and consequently lose more than they could imagine. This presentation is going to highlight the ethics, practices, laws, and regulations relevant to this article. In Mr. Chan's situation, he has breached several laws, ethics, and practices. Ethical behavior is important, and every financial advisor must act with competence, honesty, integrity, and fairness. This means all research, documentation, and communication must be disclosed to the clients. Mr. Chan acts as an agent for his principal, the clients. As an agent, a financial advisor has many duties to follow, but the main ones that Mr. Chan have broken are his duty to follow the correct procedures, act personally for the clients, and act in the best interest for the principal. Under Corporations Act 2001, Mr. Chan contravened in Section 1041H. This section highlights that a financial advisor must not engage in financial products or advice that is misleading or deceptive. In doing this, he also broke his fiduciary duty to the client, which is the trust between principal and agent. All clients who suffered losses are entitled to compensation from the Overseeing Australian Financial Services, or AFS, licensee, as stated in Section 961M of the Corporations Act. The Future of Financial Advice, or FOFA, improves legislation ensures that financial advisors comply with the regulations and obligations in order to improve the trust and confidence of retail clients. In addition to Section 1041H, he also breached Section 18 of the Australian Consumer Law, or ACL, which is very similar to that of Section 1041H, stating a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. Mr. Chan has also broken Section 961B of the Corporations Act and FOFA, stating that advisors must act in the best interests of the client in relation to the advice. This includes the research, subject matter of advice, and personalization towards the client's needs and situation. Furthermore, Mr. Chan has also broken Section 961G of the Corporations Act and FOFA, which states that the advice given to clients should be reasonably appropriate to their interest and circumstance. However, since Mr. Chan has requested the same action from all his clients, he did not provide appropriate advice and hence breached Section 961G. Lastly, Mr. Chan has breached Section 962G of both the Corporations Act and FOFA, stating that for the arrangement day each year, advisors give the client a correct fee disclosure statement. Mr. Chan did not give his client nor his licensee the correct fee disclosure statement, and therefore did not hold against the requirements of Section 962G. A solution or a method in order to avoid situations like Mr. Chan is to follow the safe harbor provision under the Section 961B of the Corporations Act, listed under best interest duty. This provision satisfies the best interest duty by taking several specified steps, ensuring that advice is relevant and appropriate to the client. It begins with identifying the objectives and needs of the client as disclosed through the instructions. Next is identifying the subject matter of advice sought by the client, followed by finding the objectives and needs that are relevant to the advice sought. From there, inquiries towards the client are made to obtain accurate information on the client's circumstances. The advisor then assesses their own competency in relevance to the client's situation. Following that, reasonable investigations, research, and assessment of a financial product are conducted, and the advisor starts basing all judgments on the client's relevant circumstances. It is important to note that taking any other steps at the time of advice provided can be regarded as being in the best interest of the client. Completing these steps will firstly make the consumer feel like the advisor is indeed acting in their best interests and have trust in retail client practices. From an advisor's standpoint, doing these steps regularly will ensure that they will never act out of the client's best interests and can act as a good example to colleagues. Licensees and regulators will also have no issues with the steps as they fully satisfy the best interest duties of a client.